All right, we have spent a lot of time talking about your rights, your individual rights that protect you from the government, and now we are going to shift to the middle of the Bill of Rights, the Fourth, Fifth, Sixth, and Eighth Amendments. We're going to deal with the rights of the accused. So we're going to focus on the rights that are protected for you by the Constitution, but hopefully that you don't ever have to worry about much. So these would be your rights that you have while you are being criminally prosecuted by the state. So we'll be talking about all of the different things that can happen in an interaction with law enforcement. And so what we've got here is a collection of some of my favorite law enforcement over the years, especially my guy T1000 over there on the right. So we'll be talking about all sorts of interactions with different stages in a prosecution of a criminal offense. First up, our objective today, we want to describe the rights of people accused of a crime. So we're going to find these in the Fourth Amendment, the Fifth Amendment, the Sixth, the Seventh, and the Eighth. We're actually going to skip the Seventh Amendment, but we're going to find all of these rights that are spelled out in the Bill of Rights. So again, we'll be able to explain the balance between individual rights and government power. So the government obviously has a lot of power to prosecute people for crimes and stuff, but we need to see what rights individuals have that are spelled out in the Bill of Rights. So we'll be trying to find out today. We want to answer the question, how does the Constitution protect people accused of a crime? So these amendments actually kind of deal with the process in the order in which they occur. So the first one we're going to deal with, the Fourth Amendment, deals with the collection of evidence, like the state trying to obtain evidence that would make it possible to prosecute you for a crime. So here we have a wonderful police officer, Chief Wiggum, interacting with an individual, and it looks like they've got a lot of evidence there. So we're going to discuss issues with evidence and what your rights may be. All right, so here's the words of the Fourth Amendment. Of course, the words always very important, but this will give us all sorts of issues to deal with. The rights of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated. No warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So there's a lot that is protected right here. Not only like searches protected from you or your house or what your papers and effects, right? So this would include like all of your belongings and collections and things like that. Even like your online stuff will fall under here. So like search histories and things like that. No warrants shall be issued without probable cause. So we'll discuss probable cause in a second, but that's going to mean that an official of the state is going to have to give a judge reason for why the search should take place, and the judge will decide whether or not to issue a warrant. So a couple of the issues that come up there and what the words of the Fourth Amendment, what we were just talking about, first would be probable cause. Probable cause means that there is reason to believe that a crime has been committed, or that there is reason to believe that there's evidence related to a crime. So this means that, like, when a law enforcement official is going to request a warrant, they must offer realistic justification to the judge issuing the warrant. They have to explain why they think a crime has been committed or why they think there's evidence related to a crime there. And it's up to the judge to decide whether or not to issue that warrant. So that's a really important step there, is that the official of the state doesn't just get to search for no reason at all. They don't just get to do anything they want or go through any kind of place, but they have to justify the reason for their search. The other part mentioned in the amendment there was the warrant, and it included these details for the warrant. So the warrant is issued by the judge and gives permission for a search, but it also specifies where the search will take place and what is being looked for. So that's going to be a really important factor for us in one of our court cases coming up here. But a warrant is not just open-ended. The warrant explains where a search can take place or what can be searched, and the warrant also explains what the law enforcement officials are looking for. So that's a very important detail of the warrant. Now, the other thing to think about here is I want to make sure, since we have just talked about the right to privacy, and we're usually talking about the Ninth Amendment right to privacy, we got to make sure that we do not confuse illegal search issues with your privacy rights. Those are separate issues. So we might be like looking at a scenario or something like that, and we got to make sure if the issue is dealing with privacy rights related to the Ninth Amendment, or if it's dealing with the government making an illegal search, which would be dealing with the Fourth Amendment. So we got to make sure we keep those things straight. They're easy to confuse. All right, so we have one big Fourth Amendment court case that deals with search and seizure, and this is called Mapp versus Ohio. So there's Dalry Mapp down there at the bottom after her arrest, and we're going to talk about whether or not her prosecution was fair. So Ms. Mapp was involved with some people in town that were like doing like running some illegal gambling stuff, and the police were looking for a fugitive that they thought was staying at her house. And so they showed up and wanted to search her house. And at first they didn't have a warrant, and then they came back maybe with a warrant. That part's disputed. But they were searching her house for the fugitive and did not find the fugitive. But they were mad because was not cooperative and all this. So what they did find was obscene materials. So basically, like she had a tenant that left pornographic books or something like that, and so they arrested her for that. Right? They arrested her for something completely different than what they came for. The question is whether or not this search was legal. Like, was she prosecuted legally? And the search was for something completely unrelated. Turned out the warrant was invalid too. But basically, these obscene materials would not have been found legally if the search was taking place for something else. And so this established an important rule with the Fourth Amendment that we call the Exclusionary Rule. So the exclusionary rule is very important. This tells us that evidence that is obtained illegally cannot be used in court, no matter how incriminating this evidence is. If it was obtained in an illegal manner, then it cannot be used in court to prosecute the person accused of the crime. So it is possible to still try this person for the crime using other evidence, but the evidence that was obtained illegally will not be able to be used. Now, the exclusionary rule is an important protection for people against the government action. This protects people from the government conducting illegal searches, which is what was going on in the situation with Miss Mapp. But this is not meant to just give criminals an excuse to get away easier. So when the police are acting the way that they're supposed to be acting, that evidence may still be used in court. So we have a couple of exceptions to the exclusionary rule here. So the first of these is called the good faith exception. So if the police come and search my house, like for example, my address is 109 North Main Street. So if they came to my house and conducted a search and the warrant said 109 South Main Street, the police thought they were doing the right thing. That's like a typo. It's an innocent mistake, and the police were not trying to invalidate my rights in any way. So things like that, like when the police were acting in good faith, those things may still be admissible in court, even though the warrant may be incorrect in some way. Like if maybe they put the wrong date on it or something like that. If the police were acting the way they're supposed to act, then this evidence is going to be used in court. Another exception to the exclusionary rule here is what we call the inevitable discovery rule. So if this evidence were going to be obtained illegally, then it can still be used in court. And so this was a court case about um, basically the police were illegally uh, questioning a man and convincing him to show them some evidence. So they obtained this evidence illegally, while at the same time, other police who were doing the right thing were like using a dog to like sniff a field for evidence, and like they were going to find the evidence fairly if the other police had not acted inappropriately. So when the police are doing the right thing, the evidence will be allowed to be used. But when the police are acting inappropriately and violating your rights, that evidence, no matter how important it is, cannot be used in court. And that's our exclusionary rule that comes from Mapp versus Ohio. All right, so there's a lot of other things about searches that we want to make sure we understand. So there's a lot of times in which a search may take place without a warrant, or that the process may go in a slightly different way because of different situations with the police. So here's a few of those. So a police officer can conduct a search if they have probable cause to think that a crime is being committed. Like let's say that they walk past a house and they hear someone like screaming for help. If they came in and like found evidence, that's legal, right? They had reason to believe the crime was being committed in that moment. If somebody consents to the search, then that search is legal no matter what, no matter what is found. So when a police officer like comes to your house and says, "Do you mind if I look around?" That's asking for consent. If a police officer asks to look around a house or a car or something like that, and a person says yes, then that is a legal search automatically. And so any evidence there can be used for for a variety of crimes. If the police make arrests, they can immediately search if they're arresting a person, they can conduct a search of that person, or they arrest you for, like, if you're speeding like really fast and you get arrested for speeding, they can search your car in that moment. Like, that is a legal search because it is taking place as part of an arrest. All those kinds of things are things that the government can do. And then, of course, if evidence is just in plain sight, like if you can find evidence of a crime, like just like looking in a like open window or something like that, then they don't need to go get a warrant to obtain the evidence. Like, police don't have to ignore all evidence of anything that they see. They just need to make sure that they've got probable cause for doing that. Couple other ones here. If police, if they can justify that they think evidence is being or will be destroyed, they can go ahead and conduct a search without a warrant. So if there's any reason to think that evidence is being destroyed, and this includes all sorts of situations, police can go ahead and conduct a search without a warrant. If police are using they're using trained dogs, and a dog gives a signal, that is enough for probable cause, right? So, you guys might encounter this at like a downtown music festival or something like that. The police walk around with dogs in the crowd, and if the dog acts a certain way, that's enough for the police to conduct a search right there. And then this last one, also really important, a co-occupant consent rule. So this means, like, if you have roommates, your roommate allows a police officer to look around. That is consent for a search. So the police officer asks, "Hey, can I look around?" And like, you're not there and you have like evidence of a crime you committed or something like that. Your roommate doesn't know. Your roommate lets the police in. That is also a legal search. So there are a lot of things that protect police or law enforcement officials when they are obtaining evidence, other than just the exclusionary rule. Now, the point here is not to the point of the Fourth Amendment is not to help people get away with crimes. That's not what this is about. The Fourth Amendment is supposed to protect innocent people from having from interactions by the state. The Fourth Amendment is supposed to protect innocent people from being prosecuted, and so that's why this is important. These are not meant to be like loopholes to let people get away without conviction. All right, now let's think about you guys. What about students here? So we have a Supreme Court case, New Jersey versus TLO. This is all of her identity that we have because she was a 14-year-old. She got caught smoking in the bathroom at school. And so when she was caught smoking in the bathroom, the vice principal searched her purse. She did not give consent for the search. The vice principal is not a law enforcement official, but he found marijuana and a pipe and a list of people that owed her money because she was selling marijuana. And so she was prosecuted, right? She was not just suspended, but actually accused of a real crime here. So, should she have her Fourth Amendment protection? This all taking place at school. This goes all the way to the Supreme Court. And of course, the Supreme Court says no. The smoking was justification of the search. That was the probable cause right there. And the Supreme Court went on to say that schools do not offer the same level of Fourth Amendment protections to students as we give to adults in the real world. If you think about it, we've got signs posted everywhere at school. Your locker can be searched at any time. A whole classroom of people might be searched, and that could include backpacks and things like that, right? So there are no real Fourth Amendment protections for you guys at school. All right, that's the first step in our process, the Fourth Amendment protection from illegal searches and illegal seizure of property. So we're going to move on and talk about the Fifth, Sixth, and Eighth Amendments here.